Good evening, everyone.
Good evening.
Good evening.
Good evening.
Hello.
Yes, good evening. Let me see. 2, 3, 4, 5. One person missing. Bar is missing, but we'll start in a couple minutes. Because I gave you all a promise, right?
You mean quick?
Yeah. I know you would remember.
Even if that wasn't accurate, I was just throwing it out there.
No. I'm sure you all know all about money laundering.
We heard about it enough.
Oh, you heard about the words money laundering, but I mean money laundering itself. Why it's so important.
Oh, definitely.
Okay, all right. Okay, so let's get started then.
Okay.
So Unit 3 is about client due diligence requirement. For company law, if you're incorporating the company, you need to know who your client is. And that means that you have to ensure that you have KYC on your clients. And KYC refers to having the passport or the national identity card, proof of address, character reference, banking reference, and then of course, checking that person through a compliance system, such as WorldCheck, to make sure that there are no negative reports on that person. You'll also do a Google check to make sure there's no blogs to find out if there's any negative news on that person. But in addition to obtaining those documents and then making a decision whether on board a client or not, you have to know your client. And know your client means that you really have to assess what is the risk on onboarding this client. What exactly is this client going to do? Do we have the risk appetite for that client? And then whether or not you have the policies and procedures in place to mitigate against any risk that that client may face in the future to your organization. So I don't think I need to go through all of the step-by-step of what is required in terms of customer due diligence, correct?
Correct.
Okay, all right. So we know that by law, when we talk about money laundering, there are several pieces of legislation that go around just the whole idea of money laundering. So normally you say a shortened form, we'll say money laundering, but we're really talking about money laundering and the counter financing of terrorism. But because that's long, people just say money laundering, but it includes both. And the legislation,
Christine,
go ahead.
sorry, just before you got too much further off of the due diligence requirements or the know your client, whatever. I did have one question with respect to the affidavits that were included in here that should be obtained for US and Canadian citizens. And I was just wondering if, I'm not familiar with that being in any of the legislation. So I'm wondering if that's just a suggestion or that's a procedure that some institutions follow.
Yeah, some institution follow, but that is not in the legislation. No.
Okay.
Yeah, no, it's not.
I mean, I see where it has, what do you want to say? Merit, but I was just curious because I hadn't come across it. Sorry for the interruption, that's all.
No. That's fine. That's fine. You could ask questions as we. Okay, so the legislation that govern, like I say, money laundering and the countering financing of terrorism are the Proceeds of Crime Act, the Terrorism Act. You have the anti-money laundering guidelines by the regulators. So the central bank has one, Securities Commission has their own, The Compliance Commission has theirs. So everybody has their own guidance for their registrants. And then you have, other than that, you have the international guidances that are out there from the FATF, the Financial Action Task Force, or the Caribbean Financial Action Task Force. And so all of them are out there as guidance. Additionally, if you want to really look at money laundering, because the risk for money laundering is very high when you're dealing with companies. And not just the companies, but the products that you offer in addition to companies. So the risk is high. So if, for example, if someone is incorporating a company to be a holding company for real estate, just off the top is going to be high risk. You then have to look at what are the mitigants in place to reduce that risk. So sometimes the individual themselves, after you've done your due diligence, can be low risk. Maybe they're not buying a development that's going to be 20 million or 40 million, but they're just buying a piece of lot for 100,000. And they have a banking reference saying that they have an account with five figures, mid-range 5 figures, and the client has already advised that they're going to the bank for financing. So that moves them out of the high and medium all the way down to a low risk. So you know the definition of money laundering, and that's where a person would seek to conceal their ill-gotten gains. And what they're going to do is they're going to put it through the process, the 3 stages of money laundering: placement, layering, and integration. And under the Proceeds of Crime Act, what they have done is they have outlined what is money laundering. And money laundering, the first offense is concealing. And concealing means, so concealing is when you conceal the proceeds of crime, or you disguise it, convert it, transfer it, or remove it from the Bahamas. And the law states that you are acting with knowledge or reasonable suspicion. The same thing when it comes to arranging matters concerning the proceeds of crime. It says that you've committed the offense if you know, or you suspect, or you ought to reasonably have known or suspected that you were entering, or you've already entered into a agreement that's going to facilitate money laundering. Then there's another 11 that speaks about acquisition, use, and possession of the proceeds of crime. Again, the law states that if you know, or you suspect, or you ought to reasonably have known that you were acquiring, or you had acquired the proceeds of crime, then of course it is an offense. It is also an offense if you fail to disclose that you know, or you suspect, or you ought to reasonably have known that the offense of money laundering or the counter financing of terrorism had taken place. And you have to disclose to the Financial Intelligence Unit or to the police officer. It is also a failure if the MLRO fails to disclose. And that means that the MLRO has the task of identifying that either they suspect or they have reasonable ground to suspect that the transaction is money laundering or the counter financing of terrorism, or they can make the decision that it is not. If it is, then it is filed with the FIU. If they say that there is no suspicion, they have to document that in their files. And it's also an offense for tipping off. This means you cannot let a client know when they are under investigation. Any questions there?
I have a question.
Mhm.
Well, when you began you said that client wanting to incorporate a company for the purpose of owning real estate is immediately high risk. And are you saying that from the perspective that that is a easy way to move large amounts of money in the with the prospect of perhaps laundering it?
Yes, ma'am.
Okay, okay. So once you have gathered sufficient details to show that the person had financial, I don't know, finances legally obtained to make this purchase, then that's when it would become low risk.
But it's a combination of things for low risk. That's one part of it. The other part of it would be the person themselves looking at their banking and characteristics references, seeing whether there's any negative news out there on the person. Remember, I said the world check.
Yeah.
So all of that come together. Now,
Right.
I'm about to mention one other factor that you have to consider, and that's whether that person comes from a sanctioned country,
Right.
or is on a sanctioned list.
Yeah.
So all of that apart, but the FATF has recently, I think it's from the beginning of last year, they have listed real estate matters as being high risk.
Yes, I recall that.
Yes. And so, and once you see real estate as high risk, and then you have to go and see exactly how you're going to reduce that risk.
You mean through gathering more information and et cetera. Yeah. And looking at, like you said, if they're coming from a sanctioned country. Okay.
Yes. Any other questions? No? So what if you have a client who's coming to you, they want to incorporate a company, and the parent of that company is on the stock exchange? How do you approach that? I see someone turning the pages.
That's not me. I remember reading about a public company.
Yes, it's in the notes.
Oh, widely held companies?
Yes.
A copy of the prospectus, extract of the share register, written confirmation of the lawyers, auditors, or an extract from Bloomberg Reuters, and a specific statement of purpose for which the company has been established is required.
Okay. So your first step, if you have a company, let's say ABC company is coming in that they want to establish 4 subsidiaries in the Bahamas to do business for whatever purpose. Now, the first thing you're going to do for that company is, based on the name, you do first your Google search. You find out that this company is a reputable company. You read in your excerpt when you go about us on their website, you see that they say that they are listed on the stock exchange, or you get a summary and it says they're on the stock exchange. Then you go to the stock exchange website, and then you conduct your research. You can read the company's annual report. You can read the filings. You can see the change in beneficial owners. You can read the risk factors. You could read everything about the company. So based upon that, how would you risk rate that company you're about to incorporate? High, medium, or low?
Low.
Low.
Yes, low, because they're on the stock exchange. And remember, any company that's on the stock exchange must be on the stock exchange that has been approved by the Securities Commission. And that listing is at the back of the act.
Meaning the FCSPA?
No, the SIA.
Oh, Security, of course, right, okay.
That. Now, when it comes to the appointment of the directors and the officers on a company that's on the stock exchange, because they're on the stock exchange, you know that the senior persons in leadership and on the board would have been approved or recognized by that exchange. So normally, go
Sorry,
ahead.
sorry. I have a question, please. I'm just wanting to confirm. So once something is listed on the stock exchange, we can take it. I mean, I guess that can be our safety measure, or could there ever be a time when, okay, a company can be listed, but it may have gone through issues? Like, should that be so reliance, or
No,
have there?
remember,
Oh,
go on the stock exchange,
uh-huh.
all reports are on that stock exchange. So you get, like, yeah, so how it is now, you can get on some, you won't get December annual report because it's a little bit early
Okay.
to be ready like March, April. But you can get the month by month reports
Okay.
that they would have given to the investors. They would include in that things about risk, changes in investment, whether they did any acquisitions. They have the report they would have given presentation to the investors before the year end. And so you can get an idea as to whether or not that company, even though it is on the stock exchange, is either not making money, is losing money.
Okay.
They've gone from doing business in these jurisdictions. You read in the report that they did a merger acquisition where they're venturing in something else in another jurisdiction. So you have to put it all together and assess.
Okay. Okay. Thank you.
We
Yeah,
also
so
requested tax returns to support, the financial, I don't know, compliance of the company that was listed on the stock exchange.
no,
That's usually,
no. Why would you get that? Because all of their filings are done with the stock exchange.
well, I don't know if their filings are, but I know we requested and received their big, whatever the combination of numbers it's called for their tax, tax return, whatever the fancy name is for it.
Yeah, but I figured if you're on the stock exchange, all those things, you have to be in compliance with all the laws.
Yes, of course. I guess it was just an added measure, really.
Yeah. So that's a widely held company. Now, let's just say the company is being owned by another company, and then above that company is a trust. What due diligence are you going to do?
On the settlor, on the beneficiaries, and the trustee, and any protector.
Agreed. What about the company below that, below the trust?
You mean the one that you're taking on?
No, the one between the trust and the one that you're taking on.
Oh, due diligence has to be done on them too, and on the directors, and evidence that their shares are held by the trust, and can be linked to, like I said, linked to the trust, so that you'll know your ultimate beneficial owner is a beneficiary of the trust.
Okay. So what if the trustee of the trust is LMN Trust Company Limited in Cayman?
We get their corporate docs. We get the due diligence on at least 2 of their directors. And I think that's it for the trust and we confirm that they are valid and that they are, check their registration when there is a public registration for the trust companies. And I'll let somebody else talk.
Yeah, because I know they're silent. I want to make sure that they know these things. Anybody else? See, because only the words are in there. I want to make sure that you understand how to apply it. Because another step in between there is that company that's in the middle. You can request a certificate of good standing, or you can request a certificate of incumbency,
Yes, of course.
You can also request that.
Yeah, which we do. You're right.
You can do that also. But what you don't want to do is an overkill. You don't want an overkill, but you have to make sure that you're satisfied at the end of the day that you have the KYC and you've done your due diligence, which means you know why the client is coming to incorporate this company. The purpose is key for money laundering, because when they deviate from the purpose is when the red flags come in. So you know there's a lot of persons when they come to incorporate a company, if they're incorporating a company for different reasons, they incorporate more than one company. Because then there's fewer questions asked.
The thing is, though, when as registered office, they can state the purpose, but it is very difficult unless an event occurs that you're made aware of. It's very difficult to monitor if that purpose is being upheld.
I agree with you, and that's a risk. That's an overall risk for the firm itself or the company.
Right, right.
Because that is why the international arena sees these companies as being risky.
Well,
And
it's
that's
really a reputational risk.
Yes, there's a reputational risk because you really don't know.
Yeah.
Because you don't know at the end of the day whether or not they say where they're from Ukraine. They said that they were just doing business in Ukraine, but come to find out they're somewhere down in Africa selling something else. You don't know.
No.
And it is a risk. So as much as we tout our horns that we've done what we had to do, and there shouldn't be a lot of pressures on us, you still have to look at the flip side of it.
Yeah.
There is a risk, and it's a big risk. So now what if 3 persons or 4 or 5 persons want to incorporate a company, but they don't want their name on the register? Carolyn, what do you do? How do you get around?
Sorry, so just ask me that again, please, Ms. Archer.
If 4 or 5 persons want to incorporate a company, they do not want their name on the register or the annual statement if they're doing a CAC. How do they get around that?
So they just appoint persons in their stead, like appoint other persons as directors?
Who's these other persons?
It could be persons known to them. I mean, I'm just talking. It could be persons known to them, or maybe it could be other members of their company that they could appoint as directors.
Yes.
And they could be they could be directors, and then they could also appoint like nominee shareholders.
That'll be for the shareholders, but if they don't want their names on record, then they would have nominee shareholders.
Oh, I got that right.
Right.
Thanks.
But on the annual statement, we are now required to indicate if shares are being held in trust for somebody.
Yes, in a nominee capacity. I mean, you're in this business and you pick one up, you can actually still figure it out. Because you can tell. Because if the company registered agent is, I don't know, ABC so-and-so limited, and you're working in the area, you know exactly that the name of the person on the register works for that company or worked at an FCSP or worked at a trust company before. And so you know that they're holding the shares in a nominee capacity.
But I mean, you actually have to write on the annual statement. If the shareholder is a nominee shareholder, you have to write on the annual statement held in trust for the actual shareholder.
I believe that would be stated on the actual share certificate.
No.
Yeah. Yeah, I don't recall seeing it actually on an annual statement, you know.
No,
It's
me neither.
required, but it's required. There was an amendment that required that when an annual statement is filed, you have to indicate who the nominee share is held in trust for. Whether it's enforced is another situation, but it is definitely was included in an amendment.
I have to look for that one tomorrow.
Yep. It was more recent, and when I say that, within the last 5 years.
Okay, I'm gonna look for that one. Because I remember seeing that.
Yeah.
Okay, I'll look for that one. And it's the same thing for directors. They use appoint persons working in the FCSP or the trust company to act as directors. So
But
it
that's
is,
not in a nominee. That's not in a nominee capacity, though.
no. No. And
'Cause
sometimes
that's no such thing anymore.
dead, right? So another thing that governs all of this client due diligence is the Data Protection Act. And you know, the Data Protection Act speaks about keeping clients' information, number one, confidential, number two, for no longer than the period for which it was obtained, that the information should always be current, and that the person should be permitted to see their information that's on the file. So all of that is a part of the Data Protection Act. And the act also speak about when confidentiality can actually be, should we say, when that duty of confidentiality to your clients, when that can actually be done away with because of the exceptions to the rule. And one is when it's a matter of national security. If a matter is litigious, or you owe the Department of Inland Revenue, those are some of the reasons why the data controller would actually allow for your information to be given out. Another one could be when there is a suspicion of money laundering. So all in all, when a trust company or service provider, they're the key persons in those positions, such like the senior management in one of those, either one of those organizations. In some jurisdiction, they have set out guidelines as to what is expected of them. And just like in all other professions, it always says that the senior management should always have sufficient knowledge of money laundering and terrorist financing risk exposure. And that senior manager should also have sufficient authority. And that authority means that they should be able to make decisions that affect their business exposure to money laundering or terrorist financing risk. So that senior management or manager could refer to either the director, that could be the manager, it could be the company secretary, it could be the chief executive, any member of management, or anybody who carries out a function in a partnership, such as a partner, or could even be a sole proprietor. But the senior manager must be able to identify and assess and manage the risk in their business. They also, like I said earlier, they have to take a risk-based approach, which means you're going to risk rate your clients and you're going to risk rate the possibility of an event happening on the risk that you have identified in your business. And as you all are aware, you also have, each company has to appoint an MLRO. So the responsibility is any one of those persons who act as the senior management is that they have to carry out a risk assessment of their business, and they make sure that they have policies and controls and procedures in place to reduce that risk. So I know all of you know that it is now required by law for businesses to conduct an enterprise risk assessment, and then an AML risk assessment. And all of that ties into the national risk assessment. That senior management must also look at the size and the nature of their business and make sure that they have to, if they have to, that they put in additional measures in their policies and procedures. And if they have subsidiaries or they have branches, they have to make sure that they include all of the functions that those entities carry out. So in summary, a senior management must carry out a risk assessment. And that's where they're identifying where there is vulnerability to money laundering or terrorist financing. They have to make sure that they have written state policies, that they have controls in place, that they have procedures, that they have identified and assessed their risk. They also, once the policies and procedures are written, they also have to review and update those policies. Most people review their AML policy every year. Some people do it every 2 years. It depends on whether or not you have changed the market sector for your clients, or whether internationally the risk has increased in the market in which you operate. Another thing is you just have to make sure that you have adequate staff, and that's trained staff, to assist in identifying your money laundering risk. Your policies, your procedures, your controls have to be communicated to the organization. Once you've communicated it, then you have to make sure that you monitor it, which means that you have to ensure that the staff are actually following the procedures, that there is a system in place for when there are unusual transactions or there are suspicious transactions. And depends upon the nature of your organization's business. You should have systems in place. Systems for due diligence, systems for transaction monitoring. Again, depends upon the nature of your business. Any comments?
I note that none of this is in our, our thing you gave us. These are, but so very familiar. These are guidelines under which act?
These are not in an act. These are guidelines that have been set out by the UK.
I thought, but didn't FIU, one of them? I mean, I know, I remember, I mean, I'm familiar with all of these, but just in order to have them, besides my handwritten notes, I just took while she was speaking. I thought they were included in some regulations or something.
No, this is for trust or company service providers.
Okay, thank you.
Yeah, but I can send it to you all.
Okay, that'll be good. I mean, just to have it
Yes.
on hand?
Yeah, because
Yes,
Be-
please.
the laws, most of the laws are the same. Because whenever we draft the new legislation, it doesn't come from the sky. Everybody looks at another jurisdiction and see what they need to tweak, what we can and cannot do. So even when it comes to these guidances, what the regulators would do is they will look at the typologies that the FATF or the CFATF or Egmont have prepared, and then they would tailor it based on the nature of their business. So the FATF has put out, but it's kind of old now, they have put out a document on money laundering and trust and corporate service providers. But this one I'm just going through briefly is a guidance that was written out for senior management in carrying out their function of money laundering. If you're under a trust or you're under a corporate service provider. And it's very clear, easy to read. So I can send you all that one. And
Okay, thank you.
it has links within it. And it also goes, after talking about the senior management role, it then goes in and talks about risk assessment, policies, controls, and procedures. And then it gives you what risk-based approach is about. So even if you wanted to use the central bank's AML guidelines, which breaks down these steps easily, like what is risk-based approach and what they look like from their registrants. This one speaks about trust and corporate service providers and what they look for in terms of risk rating your clients. And then they talk about the risk your business may face and then the actual assessment. And in here, they refer to their national risk assessment. But of course, you refer to our national risk assessment. And looking at your customers and your service provided, and then they give you a link to the Transparency International Corruption Perception Index. And if you read the papers today, you would see where the latest index came out, where the Bahamas is not low on the list. I think we were number 30, which is not too bad, but we do have to put more procedures in place in order to move up. And then policies, controls, and procedures. So it's a very simple document, and I think you could use it as a good reference. Do you want me to send you the FATF document on trust and corporate service providers? Because I can send that one also.
Yes, please.
Yes, please.
So you could have some good reading. Okay. Who's laughing?
Me.
Sometimes it's good to read these documents from other jurisdictions because then you can get a very good idea when the examiners say minimum requirements and they leave it like that. This document I'm going to send you here, it tells you what are the minimum requirements. And these are the minimum requirements internationally.
Okay.
Okay, so it'll really be helpful. All right, so that's all I had to say because I know you all know a lot about money laundering. And I know you all are very vigilant. And I know you know not to tip off. And I know you know that if there is a PEP, that you have to conduct enhanced due diligence. Any comments? I normally put a question like on this topic on the exam, which is always easy.
The comment
for
is say the
throwing that in.
question now.
Huh?
The comment is say the question now.
No, I can't answer the question now. I haven't coined it. I haven't. I was trying to find an actual case, dealing with a company that would be simple. So once I find one, if I find one, I'll share it with you all. I'll go through the Supreme Court and see if I can find one. But I don't recall any company dealing with money laundering itself. Maybe I can find one on fraud. So I'll see what I can find so I can share that with you all and we can have a discussion on that.
Okay.
All right. Any comments, questions? I hear pages turning.
I was looking to see what I wrote.
But I mean, once I send this to you, have questions, then we could discuss that on Saturday. That's fine.
Okay.
Okay.
Mhm.
But I'll start to put this together and then I'll have Mr. Pratt send you these documents and you can have a read. And if you have questions, like I say, we could discuss it on Saturday. All right.
Okay. Thank
Okay.
you.
Enjoy the rest.
Thank you.
I told you I won't stress you out.
Thank you.
I
All
like
right?
the
Thank you.
woman
Have a good
who's true to
evening.
her
Okay,
word.
good night, everybody. Good evening.
All
Good
right.
night.
Bye.
Good night.
All
Bye.
right.